The market capitalization of the coin is used to summarize all that is taught in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Have a look at this for a moment. In the midst of the legal struggle with SAC, Ripple trades 200 million XRP. What comes after this? On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Make sure you don't miss out on this opportunity. In the meantime, let's proceed with our video. Ripple has transferred 200 million XRP tokens, which are estimated to be worth around $109 million, to a wallet that is unknown for the purpose of preparing for the next phase of its legal battle with the United States Securities and Exchange Commission-ish. It was recently revealed that Ripple transferred 200 million XRP, which has created suspicion surrounding the rationale for the transfer. This suspicion was sparked when both sides of the coin were in the process of obtaining the money. Some observers in the business feel that it may be connected to the ongoing battle that the company is having with the United States Securities and Exchange Commission, despite the fact that the corporation has not provided any formal explanation for the situation. With effect from today, a transfer of 200 million XRP through Ripple. According to the information provided by Whale Alert, the blockchain payments company moved an amazing $200 million worth of XRP to a wallet that has not been recognized. This amount of XRP is estimated to be worth more than $109 million. A number of people who use the internet speculated that the move might have some sort of connection to the legal procedures that are being carried out in the SEC litigation. On the other hand, the specific cause for the transaction is still unknown at this point in time. It is possible to witness this new development in the course of the ongoing legal dispute that is taking place between the SEC and the XRP firm. Stuart Alderati, who serves as the chief legal officer for Ripple, has been given the opportunity to share his thoughts on the matter as a result of recent occurrences, particularly with regard to the decision that will soon be handed down by the United States Court of Appeals for the Second Circuit. The case is centered on the charges that the Securities and Exchange Commission (SEC) has made, which state that the XRP coin is an unregistered securities. A transaction involving XRP was carried out from Ripple to a wallet that is unknown. All of the nasty voices express confidence in the firm's position, noting out that the appellate court will either uphold the finding that Judge Elisa Torres made or improve upon it. On the other hand, the ruling will either be affirmed or expanded upon. Following the statement that was made by Alderati, it was stated that the decision made by Judge Torres would either be upheld by the Second Circuit or expanded upon. Regarding the potential of the SEC securing a remand, he played down the possibility in his statement. The best possible outcome that the Securities and Exchange Commission comes up with is a remand. This is an extremely remote possibility, especially when considering her viewpoint on the fair notice defense. The dispute has centered on the initial finding that Judge Torres issued, which was largely favorable to Ripple. This ruling has become the primary point of their attention. According to this line of reasoning, Ripple did not have sufficient notice that the actions it was conducting were in violation of the law. Furthermore, according to Alderati, Judge Torres had made it very clear throughout the SEC's attempt to appeal that her first ruling was still in place and that Ripple's defenses, including fair notice, would continue to be substantial if the matter was brought back before her court. This was stated throughout the entirety of the SEC's appeal. In the course of the interlocutory appeal that the Securities and Exchange Commission (SEC) submitted, which was ultimately unsuccessful, Judge Torres made it abundantly clear that Howey and all of Ripple's defenses, including fair notice, would subsequently be brought back into question. The question of whether or not the SEC and the SEC offered you that Ripple XRP coin was subject to securities legislation is called into question by the fair notice defense law. Alderati offered a humorous reading of the case, stating that the Securities and Exchange Commission might end up arguing before Judge Torres that she was not a person of ordinary intelligence when she decided against them. Rodi's statement revealed that the Securities and Exchange Commission could end up doing this. In Alderati's comparison of the Securities and Exchange Commission's continuing pursuit of Ripple to the well-known novel Moby Dick by Herman Melville, the chair of the SEC, Gary Gensler, was portrayed in the character of the tenacious Captain Ahab. This appears to be an odd coincidence. Alderati stated that it has always seemed to me that this case is quite comparable to Moby Dick, with Gensler playing the role of Captain Ahab. This is something that I have always thought about. When he said that the current situation is reminiscent of a combination of Moby Dick and the courtroom comedy My Cousin Vinny, he offered an extra reference to popular culture. He said that this is a blend of the two different characters. A number of unanticipated developments in the case have been brought to light by this statement. In addition to the ongoing legal drama, there is yet another factor that might have led to the transfer. A growing number of people are speculating that additional donations might be made through Ripple. Chris Larson, the founder of Ripple, recently made headlines for contributing $10 million to Future Forward, a super PAC that is supporting Vice President Kamala Harris's quest for the presidency in 2024. Future Forward is a super PAC that is supporting President Harris's bid for the presidency. In addition, many people have recognized the connection between the recent transfer of 200 million XRP and the political contributions that were made toward Democrats. These accusations, on the other hand, are not substantiated by any evidence as of yet. This is due to the fact that the authorities have not yet provided any information regarding the large transfer. Ripple's move to transfer such a substantial amount of XRP has sparked a great deal of controversy and intrigue among cryptocurrency enthusiasts. Since December of 2020, the Securities and Exchange Commission has entered a lawsuit against Ripple. The litigation is being brought against Ripple. By selling XRP, the corporation is accused of engaging in an unregistered securities offering, according to the allegations made in the lawsuit. Not only has this case had an influence on the general sentiment of investors, but it has also had an effect on the legal landscape around digital assets. As a result, the cryptocurrency market has been greatly impacted by this action. Ale Doroti, who is currently serving as the chief legal officer for Ripple, recently provided some insights into the numerous outcomes that could be conceivable for the company as a result of the appeal. Doroti made the suggestion that the Securities and Exchange Commissions could have a tough time overturning the previous ruling, which had been more beneficial to Ripple. This particular verdict had been more favorable to Ripple. A distinction had been drawn in the previous ruling between retail sales, which were not deemed securities at the time, and institutional sales, which were regarded securities at that time. This differentiation is of the utmost essential importance. In the future, XRP will be categorized and subject to regulation. There are some analysts who are of the opinion that Ripple is engaging in a deliberate maneuver by transferring 200 million XRP tokens to a wallet that they are not familiar with. Despite the fact that the company is now going through legal procedures, this measure is meant to guarantee that the company will continue to have liquidity and operational flexibility. As a result of the resolution of the appeal, the movement of XRP to a location that has not been revealed may be tied to operational requirements or positioning for potential market movements that are influenced by the outcome of the appeal. A further point to consider is that the ongoing legal battle has had a clear impact on the dynamics of the XRP market at the present time. Because of the reactions of traders and investors to the developments in the case, there has been a significant increase in the amount of trading for XRP in both the futures market and the spot market. Additionally, it is predicted that the implementation of the XRP ledger into MetaMask would improve the accessibility of XRP to developers, which may lead to an increase in the utilization and popularity of the cryptocurrency. In light of the recent transfer of 200 million XRP, doubts have been raised over Ripple's procedures and the likely outcomes of the appeal, which is taking place at the same time as Ripple and the SEC are engaged in their continuing legal struggle. Investors and market participants should make it a priority to keep themselves fully informed about the development of the case and to take into account the potential repercussions that this could have on the Bitcoin market as a whole. The necessity of legal clarity is brought to light by this case, which takes place within the framework of the ever-evolving universe of digital assets. It would be a tremendous advance if the outcome of this legal battle were to establish a significant precedent for the regulation of cryptocurrencies in the future. This would be a significant step forward. Ripple has transferred a staggering 200 million XRP, which is currently valued at more than $109 million, to an unaccounted-for cryptocurrency. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.